So before we begin, please note that this session is for educational purposes only. It is not legal advice. The goal is to provide general insights about family court processes in domestic violence cases, and you should consult an attorney for advice specific to your case. Welcome, everyone. Today, we're going to cover two vital topics in domestic violence family court cases: protective orders and the best interest of the child standard in custody decisions. I will walk you through the key steps involved in obtaining protection and securing child custody, while also highlighting what could go wrong and how things differ in various states. By the end of this session, you'll have a clear understanding of both the process and the potential hurdles that you may face. Excuse me. So, steps to obtain a protective order. Let's start with the steps involved in obtaining a protective order. A protective order is crucial for immediate protection, but understanding the exact process is key to getting one efficiently. Most states allow protective orders to be issued based on evidence of domestic violence alone, which can include physical abuse, threats, emotional abuse, or coercive control. The standard of proof is often preponderance of the evidence, more likely than not, and victims do not need a CPS finding to support their petition for protection. However, when I went to go get my protective order, they told me that the judge would tell me no and would not even consider giving me a protective order unless CPS had founded substantiated the abuse. So that's something that you have to ask per state. And how you can do that is you can contact the court clerk. You can ask them what are the requirements to get a protective order, and ask them if a founded CPS case is going to be required in getting the protective order. Here's how CPS and protective orders interact should interact in some cases. CPS investigations as evidence. While a protective order can be sought independently of CPS involvement, a CPS investigation or report can provide important supporting evidence in family court, especially in cases where there are concerns about child endangerment or abuse. CPS in custody cases. In some states, such as California, a family court judge may rely on findings from CPS if a child is involved, especially in custody disputes. But this doesn't mean a protective order is contingent upon CPS intervention. Most likely it is going to be. That's what they told me when I was trying to get my protective order. So it just depends on the amount of documentation and evidence that you can give to them. So potential barriers or considerations. Evidence of abuse. Courts may require clear documentation of abuse to issue a protective order, and some judges may weigh the absence of a CPS report as a factor, though it is not required. In other words, if CPS did not find evidence of child abuse, this may make it more difficult to prove abuse to a court, but it would not legally block a protective order. Although, when has our court system ever been by the law? Is what I want to warn you guys. So, your first step is going to be to file the petition. You or your attorney must file a petition at the family court or domestic violence court. You'll need to fill out the necessary forms specific to your state. Challenges. In states like Georgia or Ohio, judges often require strong documentation before even granting an emergency order. Be sure to include as much evidence as possible, such as police reports, photos of injuries, or witness statements. The next step would be to request an emergency order, an ex parte order. In most cases, you can request an ex parte emergency protective order, which can be issued without notifying the abuser. This provides immediate protection, typically for a short duration, days, maybe weeks. State differences. In California, the ex parte process is streamlined, allowing same-day orders. However, in states like Florida, the process might require additional hearings, delaying the protection. The next step, or step 3, would be a full hearing for long-term protection. After the emergency order, you'll attend a full hearing where both parties can present evidence. This determines whether a longer-term order that lasts up to several years will be granted. The challenge is that judges may focus heavily on physical abuse, overlooking emotional or psychological abuse. In states like Florida, judicial discretion is wide, and this may pose a problem for victims trying to prove non-physical abuse or abuse that is physical that doesn't always have signs or evidence, which is essay. So now we can talk about what could go wrong when you're looking for a protective order. Even when following the steps, issues can arise that may weaken your case or put you at risk. Some victims failed to get protective orders due to insufficient evidence. In states like Texas, where courts may require evidence of recent violence, a lack of physical documentation, such as injuries or police reports, can hinder the case. So remember to always document everything and always report every single incident to the police that you can. And the best way to script that, or how to say it, is I am unsure of the abuse that happened, but what I do know is that my child is truthful and honest, and they have told me about this abuse. Or I don't know if this abuse is true, what happened is true, but I do know that my child has this bruise or this injury, and I trust them to be true and faithful, and they told me that X did it, or Y did it, or Z did it. Judicial bias or misunderstanding. Judges in certain jurisdictions may downplay the seriousness of domestic violence, especially if it doesn't involve physical harm, or if the physical harm, which is often the case with sexual abuse, isn't evident enough, or there's not enough evidence of it, which is most cases of sexual abuse. I remember I was speaking with the forensic doctor in Maui where my case happened, and he said, do you know that there's almost never any physical evidence of sexual abuse unless the child has been severely harmed? And it's only when they've been severely harmed, rips, tears, lacerations, blood, semen, that kind of thing. And still, in many cases that I hear about, the district attorney will still not prosecute. Abuser counterclaims. This is something else that you need to be aware of. Some abusers attempt to file cross claims, alleging that the victim was also abusive. In states like Kentucky, courts might issue mutual protective orders, which can complicate enforcement and weaken the victim's case for custody or further legal protection. So there's state by state differences in protective orders. Let's discuss how state laws can affect your ability to get and enforce protective orders. And here are some key differences. Duration of orders. In New York, protective orders can last 1 to 5 years, depending on the severity of the abuse, while Texas typically issues them for up to 2 years, unless there are additional factors like incarceration. Enforcement challenges. Even with a protective order in place, enforcement can be inconsistent. In Montana, victims have reported difficulty getting law enforcement to respond quickly to violations, making it harder to feel safe even with an order at hand. So, interstate enforcement. If you need to move, the Violence Against Women Act requires that protective orders be enforced across state lines. However, some states may not be familiar with the specific terms of your order, leading to enforcement delays. You'll always need to register your order, your protective order, in the new state if you're relocating. And then I don't know if anybody has any questions about that or if it's okay to move.
I just had a question. So, in your experience, back to the district attorneys not prosecuting, even when they did have the concrete evidence of a child having tears, rips, the prolonged anuses, stuff like that, they still wouldn't
So,
prosecute.
correct. What I'm finding personally, and from watching many other people's experiences of going through this, is that there's still a possibility, no matter how much evidence you have, that you're not going to get a protective order.
Hmm.
That's not what we're going through with this. We're just trying to give people the steps so that they're more informed on how to get there. And that's
Right.
why I say this is not legal advice. Because no matter how much we talk about this, it still might not, um, it still might not work.
Right. No, I get it. Yeah. That's just interesting to me because I find the same thing. The more that I do training and the more I talk to other victims and survivors, even the statistics, when you look at the statistics, less than 1% of like rape, perpetrators are ever actually prosecuted. And it's it's very disappointing in our criminal justice system what happens out there. So that's why I wanted to ask that because I'm just like, yeah, it's like, what do we have to do? What evidence do we actually have to get, to make something happen out there?
Yeah,
So, but yeah, okay, we can go on. I just thank you for clarifying that.
of course. And just for everyone that just came in, just so you know, if you want to catch the replay of this study group, it will be on my YouTube channel. You can go to A Mother's Fire on YouTube, and that's where I've uploaded all of the past study groups. I'll have it up by tomorrow. Um, and yeah, it's really disheartening to know that so many people have gone before us who have had clearly documented evidence and still not been able to get the protections that they need for their children. And my heart goes out to all the children, and this is why I do what I do. Um, but that doesn't mean that we shouldn't educate ourselves and give ourselves the proper tools so that we can fight the whole way, because you never know what could happen. Um, and I'd just like to say that it's not a fair game. So if you do lose or don't succeed at protecting your children, just know that it's not your fault. Okay? It's not your fault. It's kind of just the way that the system is set up. And but the more tools that you have and the more that you know, then you never know. You might have small miracles that will lead you up to winning. And it's the most difficult fight of your life, but don't give up. Um, he said that he was going to found us the second time because he had reached out to my ex, who he told he was going to found us instead. And my ex started slamming the phone into the wall and calling him racial slurs and being very abusive and, violent, which proved to the domestic or to the CPS worker that he was an abusive person. Um, that was one of the first miracles that we had. Then, if you know this or not, but protective orders don't last forever. As I mentioned before, they can last up to 5 years in certain states, but most states it's only 1 or 2 years. And then after that, it's up to the judge's discretion on whether or not the other parent gets to have custody again. And most often, they do let them have custody again. Look at Rachel's case in Colorado. There was even incarceration for child rape, and they still let the father have custody. And then when the mother was supporting her children who didn't want to go, they incarcerated her for not allowing them or making them go, forcing them to go. Um, and I knew that, and I didn't want that situation to happen. And so what I did is my lawyer reached out to his lawyer and asked them to do a plea deal. And the plea deal was that we would terminate the protective order if her father would terminate his parental rights, which meant he has no legal access to her at all. And he chose to do that because in his career, he was a paramedic working on becoming a nurse. He's probably a nurse by now. And all those years of experience, he didn't want to throw it down the drain and have to become a construction worker. But he took the plea deal, so he terminated his parental rights. And that's one of the terms that they allow them to terminate the parental rights on, is if they have been, if there was abuse. And there was, and it was founded by CPS. So, uh, that really protected us. And that was the only absolute that we could get. Because if you go back into family court after a protective order, it's still up to the judge's discernment. And they say things like, oh, they'll have them do counseling or yada, 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 or whatever it could be. But I knew for a fact that abusers just, they do the bare necessity to get by, and then they go back into their old habits again. And I knew that because my brother is an abuser as well, and that's something that he did with his case. And so I was looking out for the best interest of my daughter, even though my ex got off scot-free. He never had to ever see the inside of a cell. He never had to have any accountability or consequences whatsoever. And he still has no responsibility to support his daughter in any way, shape, or form. But to me, that was worth it because at least he couldn't harm her either. Um, so I don't know if anybody new have any questions about protective orders before we move on to the child's best interest. Need to go back, you can go back and watch this on the YouTube channel. Okay. So best interest of the child standard. Um, there's steps in custody decisions involving domestic violence. Let's move on to that. And in custody cases. So, especially where domestic violence is involved, the court's primary concern is the well being of the child. But there are specific steps you should, or the court's primary concern should be the well being of the child. But there are specific steps you should follow to demonstrate that domestic violence makes the abuser unfit for custody. um, Present evidence of domestic violence. So you need to clearly document how the abuser's actions have impacted the child. Courts will look at the evidence such as police reports, medical records, and witness statements that demonstrate the abuse. Emotional and psychological harm to the child should also be presented. And like I said before, the way that you hold yourself in court and during interviews is going to sway their decisions significantly. And Marilee McLean from momsfightback.org, you know, told me that if you go in and you just say, I don't know if the abuse is happening, but because of this evidence or because I trust my child and I know my child to be honest and truthful, I have taken their account or their testimony um, to be the truth. And that's what I'm doing. Anything any sane parent would do. And I'm reporting to you, and now it's up to you to determine that. Um, and that just helps it seem like you're more neutral. Because if you are gung ho about it, if you're like burn the witch, then they see you as an abuser. They see you as somebody who is alienating the child. They'll see you as somebody who is trying to harm the other person, vengeful, out for revenge, etc., etc. So, let's see. Step two would be to argue for custody or supervised visitation. So in states like California, if there's a history of domestic violence, the court starts with the presumption that custody should not go to the abuser unless they can rebut this. You may need to argue for sole custody or supervised visitation. And then this is where the parental alienation usually comes back in as a rebuke here. And then you'll say, I don't see this as parental alienation. I see this as, I don't know whether or not the abuse is happening, but because of this evidence or because of my child's testimony and my child, who I know to be true and faithful, I'm doing what any sane parent would do, and that's bringing it to the courts or to the CPS or the police to make sure that you guys can do an investigation to find out. Um, Although I wouldn't go into court claiming a bunch of abuse is happening, or try to get sole custody unless you have significant evidence of the abuse, because um, the the courts tend to favor parental alienation over any abuse allegations. And so if somebody's being a parental alienator or alienating the other parent, they're most likely going to favor the other parent. So just take that warning and heed. So challenges like in the state of Oklahoma, courts may not automatically favor the protective parent, and abusers may still get unsupervised visitation, which makes it harder to protect your child. So I'll never forget after the opposing counsel had the supposed nanny cam video on his phone, he walked over to the judge and he gave the judge his phone. The judge looked at it for 0.1 second, put it back down, and said, I don't see anything in this. You're a liar. Never bring up sexual abuse ever again. I'm going to take custody away from you right now and give it to the father because obviously you're doing parental alienation, etc., like that. And my lawyer said that's not due process. So look up what is due process in your state so that you know the steps or the amount of um evidence that is needed for them to take your custody away. And if they don't follow due process, just claim that right in court and say, I objection, Your Honor, this isn't due process. And just putting that on the record will help you further in appeals, because once you claim that and you say, I claim it or whatever, or you just state how they're not following due process, then it will make an appeal process a lot easier for you. Okay. And then we talked about the parental alienation. So some abusers will claim the protective parent is trying to alienate the child from them. In states like Arizona and Colorado, these claims can have significant weight in the court. It's crucial to have clear evidence of the abuse and how it affects the child to prevent the court from focusing on alienation over safety. And then things that could go wrong in custody cases. Court downplays domestic violence, which happens a lot. So you'll need to focus on case law around coercive control, which is, abuse without the physical aspect. And then some states like um Tennessee, and other states will focus on more on maintaining a relationship with both parents, even when one is abusive. So you'll have to make sure you know your state laws and what they favor. In states like Illinois or Arizona, courts may be more inclined to listen to the parental alienation claims made by the abuser. And then how I see it or how I say it is that courts are set up in a way that they're going to give custody to the abuser in an attempt to do a money grab from the protective parents, because a protective parent is more likely to go to court over and over and over and over again, filing appeals and all of that stuff um, so that they can make the most money off of you. So that's why they give it the custody to abusers more often than not. So if at all possible, try to make yourself seem as, unconfrontational, as not the one trying to, because if they know you have money, or if they know that you're willing to fight for your children, then they're going to take your child away from you, because that's going to make them the most money off of appeals and fees, of court fees. So just take all this in and think about it as far as like what could possibly work for you. Always remain curious to um remain in a curious state, like remain open to having any kind of solution that could come to you from any way, and just be ready and willing to take any opportunity to try to win your case, but also try to remain appearing calm and without vengeance. um if anyone has any more questions, we have about 5 more minutes. And I hope
No,
that
you're awesome.
thank
Thank you
you guys.
so much.
Thank you so much, Margaret. And I hope that this didn't scare you guys. And I just wanted to let you know that one of my tactics that I did during the most stressful part of my situation was I would do these meditations every morning, where I would focus on what I wanted the outcome to be. And it's interesting because they did studies on a woman back in the 50s who won every single contest that she ever entered. She was like, that's how she survived. That's how she lived, was just winning contests. And so they did a study on her, and they found that she just believed she was going to win. She believed it. She really believed it. And she would live in the emotion as if she already had the outcome that she wanted. And so I did this every single morning for months and months leading up to when we finally were free and had the protective order was almost in place. And then her father terminated his parental rights. And every morning I would just lay there for an hour while my daughter was sleeping, and I'd just lay in bed still, and I'd just imagine the judge telling me, okay, you've won, you can have full custody, go ahead, your daughter is safe. And then I would imagine myself going to every single one of my friends and family members and being like, my child is safe, my child is safe, and how that felt. And I'd live in that emotion, and I'd go through every day with that emotion. And then that left me in a curious state of like, okay, maybe that would would work. Okay, maybe this would work. Okay, maybe that would work. And then next thing I knew, one little miracle happened, one after another until we won. And just doing that will help increase your vibration. And if you know that we're all every thought in our brain sends out a frequency, and the vibration that we match is what we're going to bring towards us. So I just wanted to let you guys know about that kind of neuroscience, because literally we can do a lot of self-sabotage if we actually believe we're going to lose too. So if you get yourself trained and you reprogram your brain to think, I'm going to win, I'm going to win, this is going to happen, and you're just clear with that intention, it's more likely that you're going to draw that future to you. And if you're thinking, oh my God, I'm going to lose, I'm never going to see my children again, then it's more likely you'll draw that future to you as well, because you might self-sabotage, you might wake up late, you might cry yourself so hard that you miss the opportunity or the miracle that might be trying to present itself to you at that time. And then thank you so much, everybody, for joining me today. And next week we have a special guest that is going to come on. Her name is Marissa Nichols. Marissa Nichols is a lawyer for CPS cases. She won her case like 3 times now because they just keep trying to retaliate against her. She's going to tell us how the best way to work with CPS in a way that you won't get your children taken away, from a lawyer's standpoint. So don't miss it. And if you do miss it, then go to my YouTube channel, and that's where I put all the replays. Okay. And if you want the notes from today, please just message me or DM me or email me and ask me for the notes, and I'll send them over to you. Okay. Thank you so much, everybody, for joining, and I hope you have a great evening. And if you have any other questions, please feel free to reach out to me.